Well, thank you all for coming. Yesterday was an historic day here in Minnesota when Al Franken was certified the winner by the State Canvassing Board of the 2008 Senate election by 225 votes. I said at that time that former Senator Coleman had a choice to make about what he wanted to do next, whether he wished to mount what could charitably be called an uphill battle to try to overturn the will of the people and the decision of the bipartisan state canvassing board, which includes two justices of the Supreme Court, including the Republican Chief Justice of the Supreme Court, or whether he would graciously move on from this election, recognizing that he fought a long and hard fight, that it was a very close election, but ultimately Al Franken had prevailed by what was a close but a comfortable margin. Today, we obviously all learned that Senator Coleman has decided to fight that fight, no matter how long the odds are, and no matter what the costs may be to the people of Minnesota. And that's obviously his choice. I have reviewed briefly the petition that his lawyers have served. I assume they filed it, but they've certainly served it. And it is essentially the same thin gruel warmed over leftovers from meals that we've all been served over the last few weeks. There is a repeated suggestion that there may have been duplicate ballots counted without any evidence to support that there actually were. They also believe that there were found ballots. These, I think, is a reference to the ballots that were located in Ramsey County during the course of the recount, of which until today I was unaware that there remained any controversy. But when you lose by 225 votes, and this is going to be a theme you're going to see over the next few months, when you lose by 225 votes, you have to go mining for votes somewhere. So I suppose the fact that there were 170 some odd lawful ballots cast in Ramsey County would be enough of a reason to contest them. We get a reprise of the the Minneapolis 133, where virtually every news organization in this room, maybe not even virtually, it may be every news organization in this room, has acknowledged and has written what the city of Minneapolis has said unequivocally, what the election administrators in Minneapolis have said unequivocally, what the county of Hennepin has said unequivocally, what the state canvassing board found unanimously, which is that there were 133 ballots lost in an envelope marked 1 of 5. As you recall, we have envelopes marked 2 of 5, 3 of 5, 4 of 5, and 5 of 5. At the time, the Coleman campaign seemed to want to stay in the Flat Earth Club and say that these ballots never existed, though occasionally they seem to be embarrassed even themselves to be asserting it. Well, it's back, and they seem to think that those 133 ballots didn't exist, and so that's back in their contest. Most curiously, they are both insisting that 654 uncounted absentee ballots get included, while at the same time complaining that the 933 absentee ballots that were open on Saturday were included. So it seems to be that they have problems with both the inclusion of those that all the parties agreed to, and the exclusion of the ballots that only they wanted included. Again, I suppose when you're behind 225 votes, you only go to prove that desperate times call for desperate measures. They make a series of unsubstantiated and frankly unclear allegations about unqualified voters, double voting by people, and in a new twist, they wish to throw out ballots because, I'm not making this up, it's actually in the document, because the election judges failed to initial the ballot. Now, let's all take a step back here for a second. They want the state courts of Minnesota to declare ballots invalid because the election judges didn't put their initials on the back. This is obviously not a claim we've heard before. It's not a claim that has any support in federal law or in state law, and it is certainly not the claim that a campaign that is interested in enfranchising voters would typically make. Because after all, you go to the polls, you get a ballot. I don't think any of you probably flipped it over and said, there's no initials on the back of my ballot. You probably figured that if you went to the polling place and got a ballot and cast it lawfully, that it would be considered a lawful vote. So we are on the precipice of, I suppose, the next phase here, which is where the Coleman campaign takes a very heavy rock and tries to push it systematically up a very steep hill. There simply aren't the votes there. I've been asked probably more than any other question I've gotten from you all is, how did you all do it? How did you make up this margin? How is it, tell us what the secret was. And I've told all of you that while it is flattering, in reality the reason why we made up the margin is because more Minnesotans cast lawful ballots for Al Franken than for Norm Coleman, and there's nothing that I could do about that to make it otherwise, and there is nothing that Mr. Knock or Tony Trimble or any of the other of their team of lawyers can do about it. So we will proceed from here with the next phase of this, but there is nothing in what was filed today that is new, with the exception of the initials. I mean, that's new, I suppose. But with the exception of saying that anyone whose ballot wasn't initialed should be thrown out, there's really nothing in here that's new. It's the same arguments that they've gone to the Supreme Court and lost on before. It's the same arguments they went to the bipartisan canvassing board on and lost before. It's the same argument that they've trotted out with you before. And the results will be the same this time as it was before. And, you can do the math yourselves and see that if you add up these numbers, they are not on a trajectory to prevail. So with that, I'll take any questions.
If you're so confident that Franken won, why wasn't he sworn out in Washington?
Well, I know that Al Franken won. In fact, I have this handy certificate, which they were nice enough. I have copies if people want them. They were in the contest. So the way I know he won is because there's this really nice certificate. And if you look at the original, this is actually a gold seal, and it says Secretary of State's certificate, and it's signed by the 5 members of the canvassing board, certifying the results, which shows that Al Franken received 225 more votes than did Norm Coleman. So we know he won. Now, I think the import of your question is why wasn't he seated yesterday? That's really a question that you ought to ask the Senate. The Senate obviously has its own process and procedures, and they will, they are the ones who just
hear what he's saying over that black.
Is this phase of the process any less legitimate than the process that just concluded yesterday?
Is this phase of the process any less legitimate?
Yeah.
You mean the fact that they've sued to overturn the election? Look, this is the thing about being a lawyer that is most gratifying, is that we live in a democracy where the courts are open to everybody. I have a client who has been sued to try to block his seating, or at this point that has now failed, so it's not to block his seating. He tried to block his election certificate on the grounds that he failed to pay his filing fee in physical gold. Now, the great thing about America is that the court systems remain open for all kinds of claims as to why it is someone did or did not win an election or should not be seated. And it's a legitimate, the courts are there and they're open for people to bring contests and bring claims. So I'm not here to say that it's illegitimate. I mean, that's what the courts are there for. They're to arbiter disputes between parties when they can't agree, and this is obviously one of those situations. But you shouldn't confuse the fact that the courts remain open to hear those claims with the question of whether or not those claims have any merit. And in this case, former Senator Coleman's claims simply don't have any merit.
Mark, what's in the next 3 weeks or month, what would you say, take us through what's going to happen in your view of how this plays out, how the contest plays out?
Well, I think there'll be a number of procedural motions early on. I think that there are some that the other side have already suggested. There will be others that we bring forward that go to the question of what the state courts have the jurisdiction to hear, what the scope of their review will be, how they will proceed, and then we'll obviously, as we have all along, we'll follow those rules through.
And are you folks planning to raise your own contest issues as you are allowed to right now?
We will look at that. I would expect that there are probably going to be areas where we will raise questions about whether or not there were additional, for example, additional absentee ballots that we had identified that should be counted. And just so that everyone's clear about this, we identified early on the issue of uncounted uncounted improperly rejected absentee ballots, and went to Herculean efforts to get those counted, and had ultimately some success in the state Supreme Court with the process that they came up with. As part of that, as many of you know from our press conferences and from data practice requests that you have undoubtedly done, we submitted affidavits around individual voters. So we didn't come up with a list of could be, might be, should be, which is what essentially we have from the Coleman campaign in this list of 650. Because the Coleman campaign itself acknowledges that that list of 650 is not actually 650 votes that should be counted. It's could be counted, might be counted, could be eligible. Gee, we don't know. Maybe we're wrongfully rejected. We came up with lists of individual voters, one at a time, with evidence around why it was that their ballot was improperly rejected. And we certainly believe that there were some of those individuals who, as this process went through, wound up on the still not having their ballots counted. So there'll almost certainly be some people who we bring forward like that.
Which cannot have predicted 2 months of this. Is that
2 months of this from today, or
until it's resolved? He thinks it can only take 2 months. You think it will take longer than 2 months?
so he thinks it's going to start. So he thinks by March 6th it'll be done. Because I couldn't tell actually whether it was 2 months to start or 2 months from today to finish.
That's what it sounded like to me.
I don't know. I don't have any prediction on the timing.
How much is it going to
Last
cost the
question.
Franken campaign? How much is it going to cost the Franken
I don't know.
campaign to fight?
I don't know. I don't think. I think what it costs the Franken campaign is secondary. I think the fact that this will obviously take up the time and the energy of a number of state officials, the state court system, and the like, is something that the people of Minnesota need to consider. Now, there is a provision that the Coleman campaign will have to advance by way of a bond a good portion of those costs, and will be liable for them at the end of the process. But still, it's obviously, I was listening on NPR this morning to the opening of the legislative session and the budget issues facing the state. It's obviously, I think the cost is probably more of an issue for them than it is for either of the two
Do
campaigns.
you
expect
think
the
this
shoe
Franken
is on the other
should
foot?
be-
Would you be
We had one more.
Do you expect to seek a consensus process for appointing these 3 judges that will hear it, or will you just accept the process where this chief judge can pick whoever he wants? Do you want to have a voice in that?
We'll wait to hear from the court. I don't know whether it'll be Chief Justice Magnuson, who has recused himself up until now, may recuse himself on this, or whether it'll be Justice Page, who's been essentially the acting Chief Justice in the interim of this. But we would await to hear from them about how they wish to proceed.
Do you think Franken should be seated before the contest is complete, and does Franken think that he should be seated before the contest is complete?
The decision on seating is one that is constitutionally left to the United States Senate, and that's.
So you and Franken have no
I'm speaking
opinion?
only for myself.
So then, do you think Franken should be seated?
I think that it is something that the Senate will look at, and the Senate will make a decision on.
Wait,
Franken's on the other
Franken
foot,
think on it?
would you be
Wait.
suing?
Where is Al Franken right now?
He is in Minneapolis.
And what
If
is
the
his
shoe
view
was
on
on
this?
the other-
No, what is his view on the seating issue?
I've
Does he
given-
believe he should be seated?
He's not here at the moment, and I'm.
He believes it's up to
Well, we
Senate.
tried to ask
Yeah.
him that yesterday, as you know.
It's actually not up to him, it is up to the Senate, and I
So
believe that
he
he
is
would
without
defer
an
to that.
opinion on it?
He believes
Thanks,
it's up
guys.
to
Will he
Senate.
wait, even if the Senate says it will seat him, will he wait until this contest plays out?
I think we've answered this question now, 3 of us, pretty clearly that it's up to the Senate.
Is he going to DC?
Thanks, guys.
Is he going to DC?